How is a trustee appointed? A trust is a legal document that gives one person a right to benefit from an asset that's being held by another. The person who creates the trust by granting the right in the asset or property is most often referred to as a grantor or trustor. The grantor can also name someone else to manage the trust they create. That manager is known as a trustee and has a significant role in the administration of a trust. All trustees have a legal fiduciary duty to the person or people who have a right to benefit from the trust assets. These individuals are known as beneficiaries, and the trustee must manage and administer the trust property on their behalf and for their benefit. Who appoints the trustee of a trust? The grantor appoints the trustee. For revocable living trusts, a grantor often designates themselves as trustee for as long as they live. Because a grantor is setting aside some of their own property in the trust, they commonly want to manage those assets while they're still alive. However, when a grantor appoints themselves as trustee, they still must abide by all the trustee's duties and act in the beneficiary's best interest. For a revocable living trust, the grantor can appoint someone to become the trustee upon their death. When the appointed trustee is unable or unwilling to carry out their duties, then a court may appoint a trustee to manage the trust property and handle its distributions. For example, imagine creating a revocable living trust and nominating your daughter as your successor. If your daughter passes away before you do or becomes incapacitated after your death, then a probate judge is going to decide who is best positioned to manage the trust assets. In these unfortunate circumstances, the judge most likely is going to nominate a professional trustee, often a private professional fiduciary, who is going to act as trustee and be paid from the trust assets. Does a trustee have to be appointed? Yes, all trustees are nominated or appointed, either by a grantor or by a probate court, sometimes by the beneficiaries. Further, every trustee must willingly accept their appointment. A trustee can decline to serve, for example. It's crucial that future trustees understand the extent of their duties and the time commitment that they're going to have to undertake to discharge their duties. You should always consult with someone before naming them as a trustee. There are professionals who charge a set fee whom you can appoint, and those individuals have extensive experience managing trust assets and doing these things all day, every day. If you prefer having someone you know and trust as your trustee, usually a family member or a family friend, business partner, etc., you can sit down and discuss your wishes with them when you create the trust so that they know why you're putting them in that position of power. However, make sure everything you communicate to your potential trustee is consistent with the terms of the trust. The trustee has to carry out the wishes as written out in that document, even if you tell them something different. This would be an excellent time to discuss compensation. For family or revocable living trusts, the trustee may also be a beneficiary of the trust, in which case they're going to pay themselves whatever they want because it's their money. But other beneficiaries can come to resent the control or management of the trustee that succeeds you. This is especially true when trustees pay themselves from trust assets and the beneficiaries believe those monies should be going to them. What happens when a trustee is appointed? A trustee should take concrete steps to prepare themselves to effectively manage a trust after appointment. The first step is to identify and secure all the trust assets, understand its workings, and its pluses and minuses. When you decide to nominate a successor trustee, it's a good idea to meet with them to go over the trust, its terms, what trust property is going to be held inside that trust, and where all of the legal documents can be accessed. The trustee is not only going to need to be able to locate all of the deeds, valuables, such as items in a safe deposit box, but they're going to need to have access to this property. For bank, retirement, and investment accounts, they're going to need to potentially have a death certificate, perhaps notarized copies of the trust or a trust certificate. Once verified, then the successor trustee is going to have access to those assets and be able to start administering them, but they're not going to be able to do it until then. As trustee, once you're legally in control of trust assets, it's a good idea to sit down with a licensed professional to talk about the roles and responsibilities you have so that you understand what you need to do, what you shouldn't be doing, so you can keep yourself out of trouble. Once you get past the administration phase, you can start looking at what needs to be distributed, what goes to what beneficiaries. During this time too, it's a good idea to consult with a probate litigation attorney to ensure that you're complying with the terms of the trust to make sure you're doing the things that were intended to happen with that trust. Have questions? Give us a call, shoot us an email. At RMO, we protect people like you every day. Thanks for watching.